What we found out recently in a case in California is the defense expert altered the test administration and or changed our client's answers 67 times during the examination.
TBI cases can feel like navigating uncharted territory. Your client's injury is real, but proving it, that's where the real challenge begins. If you've ever felt like you're missing crucial pieces of the puzzle, you're in the right place. Welcome to Winning the TBI Case, where Tom Crosley shares the insights he's gained from over 60 injury trials. Not just the victories, but the lessons learned along the way that make all the difference. This is practical wisdom from someone who's been in your shoes and found a path forward. Winning the TBI Case. Strategy, science, and storytelling. When Dorothy Clay Sims discovered that defense experts were systematically lying about her brain injury clients, she made it her life's work to expose their deceptive tactics. In this eye-opening interview, Dorothy shares the tools every trial lawyer needs to identify and challenge fraudulent medical testimony.
Welcome back to Winning the TBI Case. I'm Tom Crosley. Today's guest is Dorothy Clay Sims. She's a lawyer who has spent decades studying how defense medical experts operate, how they write their reports, how they testify, the tactics they use to minimize or deny injury claims. And if you've ever read a defense IME report and thought, here we go again, then this episode is for you. We're going to walk through what Dorothy actually does for trial lawyers, when you should consider retaining her, what you can learn from her, and hopefully give a practical framework for researching a defense doctor and building a cross-examination strategy that's clean, fair, and powerful. All of this without turning the courtroom into a boring medical seminar. So let's get into it. Dorothy, how are you doing today?
I'm good. How are you doing, Tom?
I'm doing great. So you and I have known each other for, a long time. Almost 20 years now, like more than 15 years for sure. So a lot of your background I'm familiar with, but we may have listeners who aren't. So I wanted to start with what drew you into studying defense medical testimony in the first place and carving out this niche in your law practice?
Well, my motivation, actually, it's this guy right here. His name was David Hansford Sims. He was my brother. He had a very severe disability. He could not ever speak, communicate. He would sit for hours on end shaking a sock. And I saw how he was treated, and it really bothered me. And I felt like I wanted to represent disabled people. And then the more I did it, the more defense reports I got, the more I realized these people are lying. And so one day, after 60 cases in a row where the same doctor said my clients were faking based on the MMPI, I went and met the creator of the MMPI, and I showed him the last report, and he started laughing. And I said, "What's so funny?" And he said, "If this doctor had been my student, I would have failed him. This is not an appropriate interpretation of the test." Because I knew that they were lying, defense experts in general, but I didn't know how. And so he actually became a friend of mine, and we spent hours together, and he would give me examples, questions to ask, and this is how they manipulated the science. And I ended up doing a lot of brain injury work because there's neuropsychological testing, and that is an area that I've seen incredible fraud. What we found out recently in a case in California is the defense expert altered the test administration and or changed our client's answers 67 times during the examination. It got so bad that during the cross-examination, the judge says, "Okay, you can stop. We know they did it all wrong." We didn't want to stop, but it was terrible. So the more I get into this, the angrier I get. I found it, I spent several years taking all these tests myself, having physicals performed on me to understand how those are altered. And then I work closely with my husband, who's a physical medicine and rehab doctor, and he ran a brain injury clinic. And he watches the videotapes of the defense medical exams, looks at the report, and then he goes into the body of the report and lists everything they misrepresented based on the video. He's done probably 700 of these. And when I asked him, what percentage of the time did the doctor actually accurately reflect what happened in the report, knowing that they were being recorded? And the answer is 0.
Some years ago, you wrote a book called Exposing Deceptive Defense Doctors. I actually bought that book, 20 years ago, maybe. I don't remember when it was published, but it was one of those 3-ring binder books that was multiple volumes, very expensive for a young lawyer at the time. But I recall that book being instrumental in helping me approach defense IMEs. This was not brain injury cases. These were typically spine injury cases. Right. But since that time, it sounds like you've been doing a lot of work on brain injury cases.
Yeah, and that book has had significant updates. It's probably twice as long. I have a lot of references to diffusion tensor imaging. I know you had a piece on that. There's a lot of politics going into articles that are written saying don't use it. It's unbelievable in that field what's happening. But yeah, the book is longer and there's a lot more updated information in it.
I need to get it. So we had as a previous guest, Stuart Casper, who you and I both know very well. And he and I talked about the concept of the citation cartel.
Yes.
And so I'm assuming that's a little bit of what you're referring to in your previous comment just now.
Well, there is such a thing. And in fact, one of the problems we have is people are afraid to talk about it, especially professionals, because a certain number of defense experts are very litigious. But yeah, when you have a defense expert become the head of a journal, deciding what gets published and what doesn't, and that individual doesn't even allow an article published by the creator of a test that is being analyzed and criticized in that journal, they don't allow the test creator to weigh in. It's bad.
I know you speak a lot around the country and even internationally, and I've heard you speak several times. You're always very entertaining. But some of the examples you give are so incredibly outrageous as to defy belief.
Yes.
And I haven't had those examples actually appear in my cases because I'm usually dealing with pretty known quantities. I mean, I've had you do research for opposition research for experts. You've provided packets of information. But what I'd like to hear is the normal, what are you doing for lawyers like me that either by helping us prep for these defense experts, or sometimes I know you'll come in and do them yourself as part of our case. Help us understand what you're doing when you don't have this crazy outlier who's lied on his resume and put in degrees that he doesn't have and things like that.
I don't know anybody else that does what I do. And I haven't had regular caseload in over 20 years. That's all I do. But, well, like, for example, if I'm looking at a report, I can see there's something. What I'll do is I'll take the report and I'll take the transcript and I will analyze what is in the transcript that the doctor misrepresented. Like yesterday, the doctor testified under oath, oh, your client has high blood pressure and diabetes, and that's why there's cognitive problems. And she told me that. Well, in the transcript, she said, I do not have diabetes and, et cetera. So I use some AI proprietary software that's HIPAA compliant to help with that. And I get a chart of everything they misrepresented. And then I go in and I have material on over 2,000 experts nationwide. And some of it's 12,000 pages long. And so I'll use software to go in there and tell me what's in the background that they testified to that's completely contrary to the report, right? And so I'll analyze that. And then I either will tell the lawyer, don't have me take this deposition because this expert did so badly, you need to save it for trial because there's no excuse what they did, which those are my favorite. And then I just tell them what questions to ask and give them the exhibits. Or I just go in and take the deposition myself. And when I do it, I have, I'm using a AI all day now. I have various AI sites open so that when the doctor cites an article, I can go in and say, what's the problem with the article? Even if I don't know where to find the article, I just describe it. In the middle of deposition, it'll come up with something like, oh, there was only 3 people in the normative database. This is not scientific. And so when the defense experts start citing the literature, it's clear they haven't read it, right? And they don't even really know what it says. I find that happens all the time. And so when you start using AI to go after them, it bothers them. So I'll either take the deposition myself or prepare the lawyer to do it. And sometimes I can look at a report and know immediately over the phone, okay, you don't need me at all. Here's the problem and here's how to fix it. I also do private seminars where lawyers will come in and discuss 2 or 3 cases. They will come to my home, and Oregon, my husband will look at the medical records and we'll tell them, these are your weaknesses. We record the whole thing. This is what the defense will do. This is how to fight it. This is what you need to do to clean up the case or to prove it.
Dorothy, it's interesting the way you described your practice, and I think it leads to what I'd like to talk about next, which is in brain injury cases, because this is a TBI specific podcast. There are recurring themes we see over and over again from defense experts.
Yes.
And what they're trying to get the jury to buy into. And so I'd like to discuss first, what are the recurring themes? I know what I would think, but I'd like to talk to you about it. And then after we identify the recurring themes, I'd like you to talk to us about your strategies for overcoming those.
Okay. The recurring themes are so predictable that actually my husband and my son, who's a plaintiff's lawyer here in Los Angeles, have been tasked by trial guides with writing a book on it. And they've got the top 30 typical themes that are spewed forth by bad defense experts. And those themes are so predictable. It's gotten to the point now when I find out who the expert is, I can write the report. I know what they're going to say. For brain injury, what they're going to say is there was no loss of consciousness at the scene and no evidence from a healthcare provider the patient was dazed. Okay. That's ridiculous because dazed is an experience that the patient, the plaintiff's experiencing. It doesn't mean that they're telegraphing it to the EMS or to the ER. And if I could digress on that for a moment, you know, I always get these reports that have normal neurologic exam from the ER and the EMS says no loss of consciousness. And there was a witness that saw it. There was a loss. What's going on? And then I came upon a bad crash, a really bad one with 7 people. And one woman was dying. She had agonal breathing. There was one EMT that was available for 7 people. And he was color coding those that were most severe. It occurred to me that the EMTs, when they're working a crash site and there's more than one person, they're not going to do a Glasgow Coma scale. They're not going to test for awareness. They're not going to ask the person, are you confused? So they're not documenting it. Plus, they may not document their records for 24 to 48 hours later, and they don't remember. Why does the ER say everything's normal? And this really bothered me. I had a theory that the ER was making stuff up. So I wrote from my own 3 ER visits over the last 15 years. All 3 of them had a tremendous amount of things that the ER doctor did in the report that never happened in reality. It was 2/3 of the reports, all 3 were false. And so my concern is, how do we prove it? And that's when I learned you can write for the metadata. In bigger hospitals, they keep track. When the doctor goes in the room, he clicks on an iPad and that starts the clock running for when he's with the patient. And if you show that the doctor spent 7 minutes with the patient, there's no way they could have done all the neurologic exam that's listed in the medical records. And they will admit to that. So we as lawyers need to start automatically writing for that information in those cases where we think that the ER minimized what happened.
Are you seeing that obtained in discovery in non-medical malpractice cases? Because I haven't seen that yet.
I have been begging lawyers for the last 12 months to start doing this when I first learned about it. Yeah. And they're just now starting to do it. And in one previous malpractice case, when I told them, and I'm going to talk about that in a minute, I guarantee you the defense expert the radiologist never looked at the brain scan. And they said that couldn't be. He wrote this long report. They wrote for the audit trails. And the expert admitted they never looked at it and signed off on the report.
Holy moly. That's crazy.
And that is the problem. My husband and I do international AI interviews. And we interviewed 2 radiologists, and it's on my website. And they both said, yes, radiologists believe that AI is better than they are. And so they're signing their names to the reports, but never looking at the scans. And what we're finding, like in one case, there was a lemon-sized stroke in this guy's brain. And AI missed it, and the doctor signed off on it. So that is an issue to be aware of for your own personal health and your family.
Wow. I've got a friend who's a neuroradiologist here in San Antonio. He does not want to do any of these legal casework, but I'm going to have to ask him about that.
Well, think about this. Another thing you can do is when they do look at it, the metadata will tell you how long they looked at it. And there was a case in Florida where the doctor looked at the scans for 60 seconds and there were 5,000 slices.
Holy moly.
And so all they did is made a movie of 5,000 slices going, 5,000 in 1 minute. The jury was furious. So you have to be careful. The other problem in a brain injury case is the plaintiff's radiologists, unless they're forensically retained, they are missing all kinds of stuff that I'm seeing when I open up the scan.
Right.
So don't rely on that if you have a brain injury case.
Yeah, I completely agree with you there. I can't tell you how many times I've had a retained radiologist, somebody I hired to spend the time to do an overread of pre-existing scans that came back as normal.
Exactly. And you can see the damage.
That ought to be part of the playbook for every plaintiff lawyer handling these cases.
Well, the other thing is the right scan to ask for. If someone wants to email me, dcs@dorothyclaysims.com, I have what you want to ask for. You want susceptibility weighted imaging at 2 millimeters. You want everything else at 1. The more slices, the more you're going to find the damage. If it's 5 millimeters apart, you're going to miss half of it. Right.
Yeah.
So we talked about, the myth that they're fine at the emergency room. Well, they're not. And how can you as the lawyer prove it? I've started asking all the lawyers that I work with, hey, I want you to ask your client to send you all text messages sent the day of the crash and the day after, and all emails. And if you get those, you may very well find that they're about half the time we see this stuff's not making sense. They were clearly dazed. Right.
Right. So I know that when we have other people, family, friends, et cetera, with the plaintiff in the ER, that becomes powerful. But a lot of times we don't, right? We just have the record.
Right. And your client doesn't remember, right?
All right. So I started this sequence of questions by saying, hey, what are some of the common defense themes? I'm going to throw out some of mine. At some point, I'd like to shift into what do we do, in your opinion, to overcome them? So the ones I often see are no objective findings on routine scans, normal imaging. Whatever the issue is, must be psychological or stress or anxiety or pre-existing depression or pre-existing fill in the blank, right? Inconsistent history. It's not really the plaintiff's fault that providers will write down historical information maybe differently, but they'll get punished for if, God forbid, if a record from Dr. A has a different history than a record from Dr. B. Secondary gain and exaggeration, almost always with defense neuropsychs, not always. And then sometimes we'll see with a biomechanical expert, the mechanism of injury was too minor to have caused this TBI. Those are the ones that I often see. I made a little list before I started. Do you think there's any other big ticket items that we need to make sure is included in the list of common defenses?
Yeah, I think the claim that everyone with a mild traumatic brain injury gets better, we know that's not true. I think the one thing that I see the plaintiff's lawyers miss, and it's not their fault, it's the doctor's fault, but there's a lot more wrong with the client than you realize. Oftentimes these people have human growth hormone deficiencies, and no one ever catches that, or they have a dysautonomia, a problem with, I always tell the lawyers, make sure somebody measures your client's heart rate and blood pressure laying down, sitting, and standing, because about a third of the time we're finding dysautonomia, which means they can't regulate their blood pressure. It can be fatal. It's very serious. So we as lawyers need to do a deeper dive into the different kinds of things that a brain injury can cause. But as to the defenses you talked about, let's start, and I wrote them down. Let's start with the normal brain scan. Well, here's how this rolls. The brain scan's normal except for the areas where it's not. And what I've had defense experts do is write reports calling them normal, but in reality, they're not describing what's on the scan. And they're avoiding it. For example, if your client has a lot of increased white matter or little white dots on the MRI, that can be due to ischemic disease or trauma, depending on where it is. The defense expert will see those lesions and not describe it and just pronounce it normal because everybody that age has those lesions. Well, first of all, that's not true. And second of all, if there's a lot of lesions, that's also not true. And third of all, if the lesions are at or not near the gray-white junction, that's trauma, right? And so they ignore all that literature and they plead ignorance. But the other thing that they're doing, they're so deceitful. I actually had to get a bite guard from my dentist when I found this out because it was grinding my teeth. It pissed me off so much. But I had this case where the doctor writes this long report and he shows all these images and he says, you can see clearly the above images are completely normal. And this is what lawyers should look out for. Okay, well, wait a minute. What is the series and slice number on that image? I want to find the image in my scan. And that's when I found out it was someone else's brain.
What?
Yeah. And you know what? This has happened to me once a month in the last 6 months. Someone else's brain.
At what? Wow. So how?
And the tip is, if there's no series and slice number, you can't find it on your own scan. And my subpoena, which I'm glad to share, says the radiologist, when they show up for deposition, shall be prepared to share their screen and show me where the images are, because they always say, oh, I don't have the ability to do that. Well, that's ridiculous.
Right.
So if you don't see any identifying factor on the scan, then it may not be your client. But if you do see a partial identification, then it's probably someone else. Plus, another game they play is if the lesion's up here, they'll show you a slice down here. Right. Or they can dial up the contrast and make it disappear.
Right.
Yeah. I mean, there's all kinds of little games that they play, right?
Yeah, I think you have to have your own radiologist to combat a radiologist.
Yeah. Yeah. And I always tell my own radiologist that I'm using, they may serve you a subpoena for your audit trail. You need to make sure you spend sufficient time on this. And that's helpful because it's better for my client, independent of if the defense asks for it or not.
Right.
Yeah. In that particular field, there's incredible fraud going on.
Okay. So how do you recommend lawyers build their case file so that the defense doctor can't get away with this kind of stuff?
Well, it depends on the doctor and it depends on the position that they're taking. One of the things that's important is to use artificial intelligence. You've got to start using it now. Although I just got a decision where a judge entered an order saying all of the prompts and the research used for AI research of the lawyer were not protected by any kind of privilege. So it's kind of a new area that we're dealing with. But the reality is this: if you can figure out a way to anonymize the medical records and feed them all in and say, tell me all the symptoms that could be caused by a brain injury, you will find stuff in those medical records that you completely ignored. Certain blood abnormalities, oxygen saturation. There's a gold mine of things. And that's helpful because I create a before and after chart where I list as many as 150 new diagnoses and symptoms. And then I say pre-existed. No. Can trauma cause? Yes. Was it found after the crash? Yes. So I've got like 150 different new symptoms, all of which can be explained by the crash. So when they take the position that it's all in your client's head, you can show that's not true. My client's depression didn't cause lesions in the brain or atrophy of the brain or an abnormal video nystagmogram or saccades or nystagmus. All you do is you pick the objective findings and say, being sad doesn't cause this, right? It doesn't cause a herniated disc or et cetera. It's ridiculous.
So actually, that's my favorite cross-examination strategy of a defense medical expert, is to go through all the medical records of my client and identify everything that is consistent with the claimed injury and make them, just basically make them teach it to the jury that here it is in the records in black and white, and this is consistent with the injury.
Exactly. And then I attach the chart as an exhibit. But here's another. Usually it's the neuropsychologist or psychologist that's saying it's all psychological, right? Oftentimes.
Yes.
Okay. So when that happens, I love it. I did a deposition yesterday of the neuropsychologist. She goes, your client has no brain damage. Okay. Did you read all the medical records? Of course I did. And here's the key question. Did you understand them all? And there's this long pause and she says, of course not. So, okay, that's a problem. And if they say yes, all you do is go into the records and look at a chart or look at some numbers on a video nystagmogram or EEG and say, what do these numbers mean? They won't know. And so they don't know what's in the medical records. And if you ask them, are you an expert on the anatomy of the brain? Because if so, I'm going to ask you questions. they almost always say no, right? And so they should not be testifying as to the cause of a brain injury when they can't interpret the brain scan, they didn't even look at it, and they don't understand the medical records. That is ridiculous. They should not have the ability to do that, right? For example, the test of memory malingering, you look at 50 pictures. Well, if you give the pictures too quickly to the patient, they can't remember them. The instructions say, let the patient look at the images for 199 seconds. The defense expert cuts the time to 70 seconds. And when you say, wait a minute, you didn't follow the manual, you did it too quickly, you caused them to fail this malingering test. And they did it on purpose, I'm sure. And when we've caught them at this, the judges have said, why did you do this? And their response is generally, I don't know. Well, we know, right? Another thing that happens is they change our clients' answers. They'll give the MMPI or a test like that where you fill in a bubble sheet, and then the doctor later goes and inputs the answers in the computer to get an interpretive report. But they change the answers. And so when we get the raw data, we can just check to see if the bubble sheet matches the printout, and it doesn't, right? I mean, that's just so stupid. It's unbelievable. And yet they're using this to conclude malingering. This case I was reviewing earlier for somebody, the doctor writes a report and says, oh, there was clear poor effort in an embedded measure. And then I look at the tape, and what he did was he gave the reliable digit span. You just repeat numbers, repeat strings of numbers, right? And if you miss too many, you're considered to have failed. Well, the doctor didn't follow the instructions and read the numbers far too quickly. So again, he made my client fail. But are any of these tests valid in the first place? No, I do not believe any of these validity tests are valid. The theory is if you don't remember the old item that you looked at, and instead you identify the new item, you're faking. Does that make sense?
Yeah. I mean, it doesn't make sense to me, but I understand the argument that they use. Yep.
Right. Here's the problem with that. Psychological research tells us that when you're under stress, you have a divided memory, which means you can't focus as well if you are under stress being evaluated by someone that you want to write a good report. That's a splitting of your attention right there. And most of these malingering tests were not normed under those circumstances, right? So you can get less than chance and it be completely arbitrary and not malingering. So yeah, I mean, that is infuriating because they're calling your client a liar and these tests aren't valid.
Dorothy, what do you do with the defense of the forces in the crash were not sufficient enough to cause the brain injury?
Okay, if that's done by a biomech or a doctor, they don't know the position of the patient's body typically in space when the crash occurred. But more importantly, what we do know is that even in low impact crashes, the research done by Michael Freeman, an epidemiologist, tells us that even in a very low impact crash, the probability that the neck injury was caused by the crash versus pre-existing arthritis is over 1 million to 1 in favor of the crash. Because people have pre-existing conditions that can clearly be made worse by even a minor crash. And they should not be allowed to get that to the jury.
Let's imagine that we're talking to a lawyer who has not a lot of experience in handling TBI cases, and they're handling a TBI case. Let's call it a mild TBI case. The defense has now designated its experts, perhaps a neurologist, a neuropsychologist, maybe or maybe not a neuroradiologist. What should that lawyer be doing next?
All right, a couple of things. First of all, make sure you videotape the exam. And you make sure that the videographer does not mount the camera on a tripod, but they're visualizing the body part, right, the whole time. So the doctor can't block it. Then you need someone to look at that. It takes about 3 hours to go through that video and analyze everything they did wrong. Then you want to get the dirt on the experts. So first of all, email me because I have stuff on 2,000 of them. I'm glad to share it. Yeah, you should also go out on your listserv and say who's had experience with this person and volunteer to share what you get. The third thing I do is I have my staff go on Lexis AI and they float the expert's name in and they get all decisions nationally. Because I've found expert witnesses are less likely to foul their own backyard, do something crazy in their own state, but they'll take more chances in a different state. I also will write for the state file of the doctor. Those state files are golden. And if someone works at a university, you want to write for the university file. Then you want to combine it all and use AI to tell you, especially if it's 10,000 pages, how many times were they limited, stricken, what ethical issues are there, what problems with their conclusions, and let AI analyze that for you. Then you want to get the video analyzed. You also want to get the raw data of yourself so you could see if it's even in your client's handwriting.
All right. So I know that you take a lot of depositions. How often are you actually doing the defense witnesses in trial these days?
Not that often, because our goal, and if our goal really is to have the witness refuse to testify or have the defense pull him. Like I was supposed to do a trial 2 weeks ago on the defense neuropsych. And after we took his deposition, they pulled him. And that's my goal. So it's extremely rare. But if we do a really good deposition, then the cross at trial is very easy. You just stay within the four corners of the deposition and make them admit to all of their misdeeds.
Okay,
right?
So my favorite crosses are short, punchy, in and out, like sticking them with a stiletto in the belly. 45 minutes, my 5 strongest points, that kind of thing. How would you structure that kind of cross, say, of a defense neuropsych?
I would do it 2 ways. One way is if they really screwed up, you pick the top 5 things and you don't talk to them verbally. You have a chart, because jurors are not listening. But if they see that chart, even if they can't read the words, they see check mark, check mark, check mark. And now I'm starting to do the charts in the middle of deposition and attaching them as an exhibit. That chart is a cross-examination. You don't have a degree in it. You don't have a license in neuropsychology. You don't have a doctor-patient relationship. You misrepresented the scores. Ding, 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 ding. You don't want them to give you any concessions because you're wasting your time. It makes them look legitimate when you do that. You want to show the jury how bad they are. Just go right for the jugular. Unless they don't answer questions directly. And I had a trial where we got an excess verdict, and I thought it was because of my brilliant cross-examination. And when we polled the jury later, they said, well, we didn't understand what that blonde lady was saying, but we knew one thing, that doctor wasn't answering her. And I thought, well, shit, that's all you got to do is let them continue to not answer the question.
Right.
I mean, the reality, and I don't know if lawyers know this, is that jurors make their decision not on what they hear, but on what they see. And if you played that deposition with the sound off, they would get it much quicker. They're watching the witness. That's what's going to result in a favorable verdict, how they behave.
Yeah. I love summary exhibits in cross-exam because that's what a jury will remember.
Exactly.
Dorothy, if there were just 3 things that we lawyers took away from today's interview that would help us to better handle TBI cases, what would that be?
I think number 1, do your due diligence on the doctor's background. Invariably, they have testified to the exact opposite of what they're saying in your case. You just have to find that deposition. Invariably, they may have gotten in trouble in various states and left, and you need to find that, right? Do your due diligence on their background. And number 2, presume everything they're saying is a lie and make them prove it. When they make a statement, ask them where the science is that supports it. Because the reality is there isn't any science that supports their position, but there is one hell of a lot of science that supports yours. And these people, with the right judge and the right set of facts, should not be allowed to testify. So never underestimate the willingness for some of these experts to simply lie. And the third thing is timing is important. Take a long time for your deposition. It's expensive, but that is what settles these cases. If you do a well enough job, you'll never have to try the case. But if you do have to try the case, you've got your roadmap right there because you've done an in-depth analysis. You've taken the time. You know what their opinions are. There will be no surprises, and you'll be ready.
Well, this has been super helpful. I appreciate you taking the time to share with us that are interested in TBI cases your exceptional knowledge that you've gained over the last 3 or 4 decades of devoting yourself to taking down deceptive defense doctors.
Well, thank you, Tom. It was a pleasure.
Thank you for joining us on this episode of Winning the TBI Case with Dorothy Clay Sims to help us learn how to better expose deceptive defense doctors in TBI cases. I'm Tom Crosley.
If today's episode helped you see your current case in a new light, share it with a colleague who's facing the same challenges in a case. Subscribe wherever you get your podcasts and join our community of trial lawyers who refuse to settle for average results. This has been Winning the TBI Case. Strategy, science, and storytelling with Tom Crosley.